Hello, everyone, and welcome to Police Off the Cuff Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD. A lot going on in the hearings for Bryan Kohberger in regards to many, many issues that are being discussed. And as we get closer and closer to this trial that is, again, supposed to occur in August, many different issues have been brought up by the defense. Many issues that perhaps the Judge Stephen Hippler in this case, may not allow, may rule on behalf of the prosecution. However, Ann Taylor and her other assistant attorneys are trying very hard, are working tremendously hard to present a robust defense for Bryan Kohberger. And that, of course, is her job. But many parts of this defense, perhaps, are not going to pass muster with this judge. And that, for the defense, of course, is not how they would like it. You know, how they would perhaps go about this. They're raising many, many issues. And one of the issues was an alibi for Bryan Kohberger. Does he have an alibi? So a new legal battle is brewing over this. In a new filing, the prosecution argued the judge should limit the evidence Kohberger's attorneys can present to support his alibi for the November 2022 murders of Kaylee Gonsalves, Madison Mogan, Zaina Canolo, and Ethan Chapin. So limited. And what does that mean? Well, the defense is making an argument that Bryan Kohberger was out for a drive in no specific area or place. They call this the stargazing alibi, right? And that's his alibi. And they presented no witnesses to be able to testify to that. So the prosecution is arguing that if the defense does raise any argument about alibi, that would have to come from Bryan Kohberger and no other source, according to ABC News legal contributor Brian Buckmeyer. The prosecution is also requesting to ban the defense team from offering any psychiatric evaluations into evidence. This after summaries of court documents in the case show the defense filed a motion Monday to strike the death penalty regarding autism spectrum disorder. As of early Wednesday morning, the full documents were not publicly available online, and it was not immediately clear whether Kohberger has been diagnosed with autism spectrum disorder or if the defense was seeking a diagnosis. Prosecutors also asking the court to bar references to alternate culprits unless they have evidence specifically connecting them to the homicides. So now we're getting down to the nitty-gritty, to where we're going to actually, this Judge Stephen Hippler, is going to have to rule on some of these motions going into this trial, because it's slated to start in August. So we have to go into this trial knowing where both the prosecution and the defense is. And many may say that the defense is raising all kinds of issues that they know the judge will rule against them on, but they need to make these motions to show a vociferous defense of this client, Bryan Kohberger. So folks, hold on to your hats, hold on to your loved ones, hold on to your cup of coffee. You're about to enter true crime from a police perspective. You're about to enter the off-the-cuff zone, the police off-the-cuff zone.
There has to be some common sense.
They were the ones who called 911 to get him help, and now they're calling for change.
And now a word from our sponsor, Mando Whole Body Deodorant. The thing I like most about Mando Body Deodorant is that it lasts all day and leaves me feeling clean and fresh. It doesn't quit even under the harshest heat and humidity. The fresh feeling keeps me dry and confident. No need to worry about unsightly sweat stains. Mando's starter pack is perfect for new customers. It comes with a solid stick deodorant, cream tube deodorant, 2 free products of your choice, like mini body wash and deodorant wipes, and free shipping. As a special offer for listeners, new customers get $5 off a starter pack with our exclusive code. That equates to over 40% off your starter pack. Use code POLICE, POLICE, at shopmando.com. Shopmando.com. Please support our show and tell them we sent you. Smell fresher, stay drier, and boost your confidence from head to toe with Mando. So many of these issues that we are speaking of, that the defense has raised, specifically the alibi. It might seem very simple to raise an alibi, but if you're going to raise an alibi, then you need to have someone that you could say, this is the person that can testify to Brian Kohlberger's whereabouts, his activities, what he was doing during the hours that he's being accused of these murders. So this is Brian Thompson yesterday in regards to this.
It has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders. The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. It talks about partial corroboration of a partial alibi, which frankly, the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because his phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself. If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point. And to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
I don't believe that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was a significant time, or a notable time, before the homicides themselves occurred here in Moscow. There's nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone experts on the activity of the defendant's cell phone and what direction it was, but that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 4:06.
Yes, sir. Thank you.
Until we're approaching.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration. Now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue. And I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on and 4, so whatever it was.
448.
448. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi. And a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513, subsection 3, that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce.
So quite interesting here. Of course, District Attorney Bill Thompson is saying if there's an alibi witness, we need to know who that alibi witness is. We need to know the name and what the alibi witness is going to say. However, Ann Taylor, you saw her come on, and she basically says they do not have an alibi witness. What they have is a cell phone expert by the name of Cy Ray, who will testify and partially corroborate the whereabouts of Brian Kohberger, his alibi being that he was driving around looking at the stars, and he'll semi-corroborate that. However, Bill Thompson said that Brian Kohberger is free to testify to his whereabouts, which is never, ever going to happen. That's not going to happen. And then, of course, Ann Taylor got all ruffled about that, saying, oh, that's impeding upon his right to remain silent. Well, you can't have it both ways. He has a right to remain silent, then he doesn't testify, period. And this is the argument in court. So quite interesting. And this man, I think, is staying above the fray, and his rulings, I think, have been pretty solid. He's not taking one side over the other. I believe that he's being quite fair. There's many people out there, oh, the judge is ruling for the prosecution. I think the judge's rules and rulings are based upon the law, and he is using the law to make his rulings. This is from Law and Crime.
If that's allowed to happen, then Mr. Kohberger is colored with an opinion or a way the jury will view him that is unfair. And our request is that the court not allow the state to label him in testimony as a psychopath or a sociopath, because any kind of testing is unreliable. That would relate to, or that would become problematic within the rules of evidence to do so, and the inflammatory nature of those kinds of labels would.
I'm not aware of any testing that has been done that has reached that conclusion. Am I missing something?
You are not missing anything. There has not been any testing. There has not been any labeling.
Now, a lot of people were confused by this request. Why is she asking for this? Ann Taylor said it was simply preventative, but prosecutors said they weren't going to use those words anyway.
You know, they're talking about using the words, inflammatory words like murderer or psychopath or psycho. And the prosecution had no intention of using those words to label Brian Kohberger. Nor would you, any prosecutor, use those words. You would use the word the defendant, right? Or the suspect or the accused. No one's going to call the accused or the defendant a psychopath or a psycho or the murderer, because he's the accused. He has the presumption of innocence. So again, yeah, a little bit strange as to why Ann Taylor requested that.
Here's Judge Hippler.
With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence. And I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things. But for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms or their equivalents.
I want to take just a moment to tell you about.
So the state, the state would not use those terms to describe a defendant, but it just, the fact that it has to be stated is probably because the defense is raising the autism spectrum disorder to defend against the death penalty part of this case. And if the death penalty is in fact requested in this case, then that would, of course, be the defense's. That would be the defense against this. Obviously, is his autism spectrum disorder. So does that come in line with this? And that's what we're going to find out. And that's why the defense is looking ahead to that defense in case he does get convicted and this does go to a death penalty case.
There's too great a risk that constitutionally protected mitigation can be reliably assessed by a jury. The impairments cited by the United States Supreme Court in holding that the death penalty is unconstitutionally reliable for juveniles and people with intellectual disability apply with equal force to people with ASD, and specifically to Mr. Kohberger given his deficits. Courts are expected to apply general legal principles from Supreme Court precedent to new facts. The United States Supreme Court just reiterated this in Andrew versus White, a 2025 decision decided January 21st, 2025. The general legal principle here is that the Eighth Amendment and its requirement of heightened reliability in capital sentencing applies. Unreliability exists when a defendant has an inability to present mitigation evidence, which creates an unacceptable risk of wrongful execution. The four impairments in Atkins, which apply here, are A, less able to give meaningful assistance to their counsel, B, demeanor may create an unwarranted impression of lack of remorse for their crimes, C, typically poor witnesses, and D, mitigating evidence of ID can, quote, be a two-edged sword that may enhance the likelihood that the aggravating factor of future dangerousness will be found by the jury. All four of these impairments apply to ASD generally and to Mr. Kohberger in particular. As to less ability to give meaningful assistance, extremely rigid thinking, he perseverates on specific topics, processes information on a piecemeal basis, struggles to plan ahead, and demonstrates little insight into his own behavior and emotions. He may understand the definition of mitigation, but he has no ability to assist us and understand if what might be mitigating and why. The impairments that he has go all the way back to his very young years, where he walked on his tippy toes, rocked on all fours for extended periods of time, could not engage in imaginative play, wrote his fives upside down and backward. He was provided with extensive supports in school. He was evaluated for ASD, but not properly diagnosed. And bring that to current time where he is at age 28, where he has few personal relationships. He does not have any insight into things like the fact that he once volunteered at the Special Olympics is mitigating, or that he helped save someone's life on the job, and that's mitigating. He can see the logic in the word mitigation, but he has no ability to understand and help us develop a case for him for mercy. His demeanor, he has a limited range of facial expression, odd eye contact, and intense gaze with subtle rocking, sitting very still. This is important because of the impact that jurors assigned and give tremendous weight to perceived remorse or the lack thereof. So again, I'm talking about not phase 1, but if we get to phase 2, this perceived remorse and their decision about the death penalty. As evidenced, as I've explained, by the media demonizing his appearance. As a poor witness, he has difficult picking up on nonverbal cues, tone, and
So this is the defense giving all the reasons why the defense of autism spectrum disorder should be allowed in regards to the death penalty phase of this case. But they're putting it out there now to get it sort of on record with the court. A lot of these things are sort of tough to believe for the fact that Bryan Kohberger is and was a PhD student. So him not understanding certain things, you might ask, how did he compete at a PhD level if all of these things are true? And these are the thumbnails you're seeing on the screen are some of the different motions that the defense has filed during this case. And it'll be interesting to see, of course, how Judge Stephen Hippler rules on a lot of these motions from a very competent counsel for Bryan Kohberger. So, folks, this has been Police Off the Cuff. If you're not subscribed, hit that subscribe button, give us a thumbs up, ring that bell, share us with your friends and your family, hit that like button. It really helps us. If you want to contribute financially, we have a Patreon with 4 different levels. We also have a YouTube channel membership with, count them, 5 different levels. And you can join us via our YouTube channel memberships. We appreciate all of our fans, our friends, our subscribers who support this show every day of the week. Listen to it, give us a thumbs up, and share us with your friends and your family. And you've become part of the Police Off the Cuff Real Crime Stories family on YouTube. And we appreciate you. Have a great day, everyone. I'm Bill Cannon from Police Off the Cuff. God bless.
One episode just ain't enough.